All right, then we'll move on to the Michael Wilson case. Okay, would you please announce your appearances?
Yes, Your Honor. Daniel Paz for the movement.
Michael Wilson, the debtor.
Okay, Mr. Wilson, you need to step over to the lectern when you speak.
Very well, sir. First of all, good afternoon, Your Honor.
I just wanted you to announce your appearance.
Michael Wilson, debtor.
Right, we've got, actually, you've got several things that you've asked me to look at today.
Yes, sir.
And I don't know if I can look at two of them because I don't know whether the notice has been adequate under the circumstances. The motion for examination of a party, I believe Mr. Paz's client, and the motion to require them to, I'm not sure what you had in mind, but to prove that they have the capability to speak respecting the property, I believe. Is that right?
Yes, sir.
Okay. All right. Then we also have the objection by Mr. Paz's client to the debtor's section 362I1 statement, which is also to be regarded as a motion for relief from stay. Is that correct, Mr. Paz?
Correct, Your Honor.
Okay, I'm not sure. I think perhaps the best way to proceed is to start with Mr. Paz, since we definitely have sufficient notice in his case, and we'll go from there.
Sir.
Thank you, Your Honor. Daniel Paz for the Bluffs at Paradise Creek. Your Honor, in essence, our objection is asking the court to confirm that the automatic stay in this case does not apply to my client. Mr. Wilson has filed two bankruptcies. The present bankruptcy was filed on July 30th, 2014. Under 362, there is an exception to the automatic stay that does not stop actions related to an eviction that is attained prior to judgment, or prior to the bankruptcy being filed, excuse me, Your Honor. And in this case, my client, the Bluffs at Paradise Creek, obtained a final judgment from the Tarrant County Court at Law number 1 on June 12, 2014, which was prior to the present bankruptcy filing that's before the court today. Within that exception, there is a savings clause that allows debtors to file a certification with the court, acknowledging that there is a judgment against them for eviction and allowing them to cure any default. However, under the Grigsby opinion out of the United States Bankruptcy Court, Southern District of New York, that savings clause has been held to be limited just to defaults regarding monetary issues, failure to pay rent. The eviction in this case that my client obtained against Mr. Wilson was for holding over. Lease agreement terms, he failed to vacate. We were able to obtain from the Tarrant County Court at Law number 1 a judgment for eviction based on holding over. It was not an eviction for non-payment of rent. It was merely limited to the holdover issues. Based on that positions, we're taking that the automatic stay 1 does not apply because we obtained the judgment prior to him filing bankruptcy in this case, and even if it did apply, that the savings clause does not save it because it's not a non-payment of rent issue. So we're asking the court to enter an order confirming that the automatic stay does not prevent my client from going forward with enforcing the final judgment entered by the state court.
Mr. Wilson?
Yes, sir. Good afternoon, Your Honor. I am being through Mr. Paz has scheduled a hearing today to answer about the holdover eviction. I am being denied the right to renew my lease agreement and as well as a right to a fair housing and an application out of retaliation from the landlord. She was ordered to return some money back that she overcharged me for by the director of risk management for her property owners, and the next day she came and gave me a notice of non-renewal. Now, the complicated part, Your Honor, is prior to my residency here at the Bluffs of Perry's Creek, I had received a forced eviction by the same company in Irving 3 years ago, which left me homeless. I finally, and that occurred in June 20th of 2011, and within 15 days, somehow, they were able to report a collection amount on my consumer credit report within 15 days. It never afforded me the opportunity for the window which the law allows for with regard to credit report, the 30 days to dispute the balance.
Don't feel bad. After all, Mr. Donald Trump gets a great credit report, and he's the biggest deadbeat in the country.
Yes, sir. But however, sir, it was complicated for me to maintain residency, so I was moving around from hotel to just sleeping in the car to different places that were not suitable for living. On December 12th of 2011, I was finally able to get an appointment through the Department of Veteran Affairs HUD Bashes program, and I was still found to be ineligible because I wasn't homeless enough. There's a thing in the law that's called the McKinney-Hurd-Vento Act, which defines a person as being chronically homeless would have to be moving around at least 6 times within a 2-year period. And I just got kicked out in June. But however, I was still homeless. So after I did finally get into the HUD Bash program, I got a housing trust voucher, and I did get tenancy at the current location I'm at right now, the Station 3700, which is formerly known as the Bluffs at Perry's Creek. And after the notice of non-renewal, my income changed, and so I wasn't going to be eligible to continue to be part of the Housing Trust Voucher Program. Since the landlord retaliated after giving the notice of non-renewal the very next day after being ordered to return the funds, and then when it came down time to me to get ready to move, I was asking, I gave notice 60 days prior to moving, but I was still interested, although that she had issued the notice of non-renewal, I was still interested in releasing the apartment. I was never late on my rent. I had never received a lease violation or anything. Sure. And the troubling part, Your Honor, is not only me, but there were 44 evictions that was filed by the landlord under an assumed name that has been whose charter was forfeited by the Secretary of State of Texas, and she did so. Continued to file evictions for a whole year after being notified that she was not eligible and not authorized to continue her charter. And that information I had certified, and I did forward it with one of the conditions and actions I asked the court to entertain today. But however, since that time, Your Honor, there's 2,700 evictions that's been filed within the Justice of Precinct Court precinct 2, just a piece of precinct 2, and 44 of those are Ms. Ramirez. And just after hearing the news in the trial court that she was not authorized to continue under that assumed name due to forfeiture, then there's no more eviction. Amazingly, she just fixed everything. So, and as of yesterday, there were a couple more evictions that trickled in under the assumed name Station 3700, which is not on file as well with the database of corporations. Mr. Paz mentioned that there was a previous filing for eviction, and in fact, there were 2 previous filings for evictions. One was in November of 2011 when I was initially placed as homeless, and the other was on June 24th of this year, Your Honor. I did an emergency filing because Mr. Paz had petitioned the court for writ of possession and had placed a sign on my door to kick me out, and I had nowhere to go. I couldn't get another apartment due to the other debt they forced me into, which I've disputed over and over and over and over from the time I was homeless up until today's date. And still, there's no resolve.
Let me interrupt you, because a lot of what you're talking about is stuff that I can't deal with.
Yes, sir.
To begin with, you filed under Chapter 7, which means that to the extent that you have protection, it's only going to last until you get a discharge. The automatic stay is going to expire automatically once you get a discharge, which will be, you filed on, well, it shows 7:30, but you were saying 7:24. So, and you'll get a discharge about 60 days after your first meeting of creditors, which will be sometime probably in the next 2 weeks or so.
Yes, sir.
You've already got a trustee, Mr. Brown, and so to some extent your protections in this court are limited. Secondly, I have very limited jurisdiction, and for example, to the extent that you're arguing that they wrongfully sought the eviction against you, I doubt seriously that, well, I not only doubt, I know I don't have jurisdiction to hear that. That's something that would have to be heard in state court. So I'm not sure that I'm the right person for you to be talking to and telling your troubles to, because I may not be able to help you, even assuming that everything you say is correct.
Yes, sir. Yes, sir. And I can... Go
ahead. I just want you to understand that I'm probably going to say I can't do anything about that. And if I grant the motion, I don't want you to think that I'm not listening to you. It's just that what you're talking about is stuff that I can't do anything about. The Supreme Court said so, and as little as I like it and would prefer that they said something else, once they say something, it's fact for us.
And sir, this matter is still on appeal, and I have looked for an apartment, and I had an apartment. And when the last filing was dismissed, the renter told me that he was not confident in leasing an apartment to me until after I had the meeting of creditors, which was supposedly had happened on July 29th. And the current one is scheduled for
I do that when the lawyers forget to file their motions for an from stay. You can step down now then.
Yes, sir.
Okay. All right.
With regard to my issue, Your Honor, for the record, I'd like to introduce, as Movement 1, a certified copy of the final judgment from June 12, 2014, that awarded the Bluffs of Paradise Creek possession in an eviction judgment.
All right.
have an objection to that, sir. A rebuttal.
It's a certified copy of the order, so all what he's doing when he presents it is saying that the order is real, was entered by the County Court of Law #1, and that's all that it amounts to. It doesn't. It's not whether or not they were candid with the court in getting it. I mean, I'm assuming they were, but I just must take it at face value. So an objection would not be in order to that.
Very well, sir.
All right.
And again, Your Honor, with the court entering the bridge order, it's our position that the automatic stay does not apply to my client because we obtained an eviction judgment.
Yes, I understand. And I've looked at the, let me look again at the provision to make sure. Okay. I do not see that I can do other than uphold the objection that they filed to your, based on your statements from the lectern before. I don't see that I can do otherwise than sustain their objection to your filing with the court to the effect that you will cure a monetary default where there is no monetary default. So I don't see that I have much alternative under the terms of the statute other than to sustain the objection of the lessor. That does not preclude you from later challenging whether they acted properly with respect to you, whether under state law or federal discriminatory law that can be addressed. I don't know. That's up to you to find out. I would encourage you, however, to talk to a lawyer about it.
Sir, I'm going to give notice. I want to file a motion to stay pending appeal. The court's ruling, I'm a disabled veteran.
You've got 14 days from today to file a notice of appeal. I will not waive the 14. days, Mr. Paz, and I normally do not do so. And if you get an appeal heard, I will not give you a stay pending appeal, but it's quite conceivable that the district court will.
Yes, sir.
All right?
Yes, sir.
All right.
So, Your Honor, you're going to enter a bridge order as to his motion to continue the automatic stay.
Yes.
And grant our objection as to
Yes. All right?
Yes, sir.
All right. Thank you, gentlemen.
Thank you.
We'll be
Yes, sir.
adjourned.